believe the last clause we had looked at was that of commuting accident, and we are to pick up now with compliance power. So Ministry, I now turn over back to you as we progress with clause 4.
Thank you, Chair. Compliance power. After the Chief Parliament Council raised that in the definition of compliance power, safety and health representative should be deleted and replaced with safety and health representative in lower caps. Legal reform also raised that compliance power. Is this term used with reference to the safety and health representative anywhere in the bill? The Ministry respond by saying, based on the amendments previously proposed by the Ministry, this term may no longer be necessary. We will revert after we have seen the minutes in relation to the provisions in question.
So the Ministry is of the view that this term is no longer necessary. However, you will not move for the deletion just now. You'll wait until the notes are made available.
We remember the conversation with Sergeant when she was saying that it was a bit vague.
Yes.
So we just want the Minister as a reference point.
Okay, fine. Proceed.
Condition. The Ministry is proposing that the term be deleted and that the word be given its ordinary meaning.
Any comments, Mrs. Silibone? Okay. Members, we agree? Yes. Proceed, Mr. Mohan.
Contractor, Legal Reform Department.
Yes, Mrs. Silibone.
Chair, I just think we need to reconfigure the definition of construction, which I will do, and when I'm submitting the draft to this clause, we'll look at it again, because we have already defined construct to include assemble, erect, reconstruct, reassemble, and re-erect. There's no need to use that same language throughout in the definition of construction. You see where we keep repeating the same things? So we will only repeat things that are not, and it said includes, it's wide. So I'm going to look at it and fix it, and I'll let you see what my draft is.
Okay, but that's the next. We are at contractor, then we go to construction.
No, construction comes before.
Oh, okay.
No, because it came here right after. It's not mentioned at all in the matrix. I just wanted to alert you to the fact that it requires redrafting, Chair.
Okay, very well. So what, in terms of construction, are you saying that we'll just treat both as one, and you will come back in regards to both of them?
Either we do that, or we just delete the words that are used to define construct in the definition of construction.
Okay.
You understand what I'm saying? Because we have already said it includes assemble, all these things. So there's no need for us to be repeating it in.
Okay.
Yeah.
Very well. So we'll hear from Ministry. Let's just take construct and construction before we look at contractor, based on how it flows in the on page 6 of the bill.
So we're looking at construction.
Yes.
All right. The OPC had raised a definition.
She had made a suggestion.
So, yes, we are okay with the suggestion by CPC.
So the suggestion is that you will deal with them as what? Yes, at a later date. So you can proceed now to deal with contractor.
Contractor. Legal Reform Department is saying that this definition lacks clarity And JUSPA is also saying that the word contractor needs to be explicitly described to ensure that the term is not used to apply to security guards and other workers who qualify as employees by the ILO definition but are engaged as contractors in the Jamaican situation. So the ministry's response is that it is recommended that the definition for the term contractor in clause 4 be replaced with the following. Contractor means a person who is engaged under a contract for services and includes a person who or a group of persons that under one or more contracts or agreements carries out or directs the carrying out of work at a workplace. The proposed definition seeks to ensure that workers who are labeled as contract workers are not excluded. The previous definition only encompassed contractors who direct activities at the workplace. There are several well-established common law principles which are used to determine whether a person is employed or engaged under a contract of services or a contract for services. It is the ministry's view that security guards are employees and thus would not fall under this definition of a contractor, irrespective of the label utilized by the person conducting a business or undertaking to describe the relationship.
Members?
Chair,
Yes, Member
I think we have to look at 7 when we deal with this clause 7. Because 7 describe a contractor or a subcontractor as an employee, as a worker. How does this definition of a contractor fit in? Especially when you're saying here that it's a contract for service that determines that you are, that's on page 7 of your thing. It's a contract for service that makes you a contractor. And so if you are a contractor because you have a contract for service, you're also an employee, given the distinction of contract of service versus contract for service. Can this stand together? Just want to start by clarifying that.
The problem we had is that the committee had looked at clause 7 before, but had not looked at the actual definition of contractor, which has to be read when you see a contractor in B. So it's now we're trying to highlight the definition of contractor. So once the term contractor is used here, it's in the context of this definition that is in the bill, which we had not examined at the time that you looked at the clause. So what we found is that there is a weakness to the definition because it is only speaking about somebody who directs the activities of one or more PCBU or workers involved in a work at a workplace. So a contract worker who is not directing activities, in our view, is not necessarily covered under this definition, because when you use contractor, you have to look at that definition to interpret it. So it was being interpreted by everybody in a certain way without looking at the definition of contractor.
Not clear.
So is it that you're now seeking to define contractor as outlined in 7.1b? Because my notes tell me that there were some concerns that were raised during those deliberations. So we were trying as a committee to protect all workers, including a worker who might be cited as a contractor. That once you enter a premises to do work, whether you are directing or being directed, there has to be a duty of care by the persons conducting business for that establishment. So am I to understand now that based on what is being advanced here, is it a determination that you're now going to define contractors separate and apart?
Well, contractor was always defined in the bill on page 6. But the problem I am seeing, we always intended to capture contract workers, all workers. When I look at it, I think this definition is actually not capturing our true intent, because it's limited it to a certain category of contractors. So what I'm trying to do is see how we can refine it to make sure that it captures what we intend. Because it,
So
well,
that's what we need to find out. What are your intentions?
all right, persons engaged under contract for services, which should be all contractors, because remember, an employee is employed under contract of services. So I'm trying to capture the contract worker plus the true contractor on a construction site. Because this definition, when I do my research, it's not from New South Wales, it's nearer to Alberta, and they were heavily focused on construction. So I still think this contractor is more looking after a contractor on a construction site per se.
So this, which one you mean?
The one in the bill on page 6.
All right.
Which is not covering the true policy intent. Yes, it's there in the bill. But when we were looking at the clause, we didn't go back and also examine the definition that is in the bill at the same time. So I'm trying to highlight that there is a weakness in the definition of contractor, which will affect our application of this bill to all contract workers like as we intended.
Yes, so members, I think it is clear. A broader definition of the word contractor is being proposed now than what was originally stated. Because as is worded here in the original bill, contractor is limited to the person who directs the activities at the workplace. But a more broader definition has been recommended here. So this is what is being asked of us to approve. The broader definition as is now put forward by the ministry.
What does that mean, Chair? Because if I could ask one of the people, technical people, if they could pull the definition of worker under the LRID for us, which says, it's a nice formulation which says, whatever the form of the work. So it encompasses contractors, so it could encompass people at motor sales, for which IDT had to make an award. It encompasses security guards. But I'm not sure, and our definition at clause 7 in this bill include those people as workers. But this bill also goes on to say contractors, say example, working with GPS, are consider person conducting business and link back to the original employer. Because we went through that and GPS made their submissions. So I'm a little confused as to whether the definition of contractor here, even with them changes being proposed, whether that damages us at 7, and what we intend at 7 to make the worker all encompassing. And that's what I'm not clear on.
Yes, Mrs. Bennicamp.
Yes, although the LRIDA uses the term worker, you will notice that most the labor laws use the terms in Jamaica, employee and worker interchangeably. So it really is an employee that is being covered. The term is being used interchangeably. So it will not capture, for example, the contractor. The employee who is mislabeled as a contractor, that is who it would cover. That's what it was intended. But this worker here is wider than that. As we were saying, because it's occupational safety and health, we did not want to debate in court as to, is this person an employee, is this person an independent contractor? What we were trying to cover in the definition of worker is to go wider. So even though in labor law, it's Worker there is really the concept of employee as we know it, which is under the LRIDA.
I'm not asking, Chairman, for an adoption of the definition under the LRIDA, and I'm well aware that there are different definitions. We have a resolution in the Senate calling for us to adopt that LRIDA definition to all the definition of workers. But that's a different thing. So I'm aware of those difficulties. What I'm trying to see is how do we, at page 6, speak to the contractor in the definition, and at 7.1b, speak to the contractor or subcontractor as a worker. Is there two different set of people? For example, I could see somebody who contract, let's take bauxite, contract to do the mining, employ a number of workers. That contractor is not seen and could not be seen as a worker on the 7.1b. However, if he calls the people who drive in those trucks or the tractors contractor, as so many employers want to do, then they're still workers, notwithstanding, because they don't direct and control and all of that. So I need to be clear that we defining those who really are employees, like the security guards, don't call contractors, from the set of contractors who are real employers. And I don't know if this does that. So that's what I want to get around.
Mr. Chair, just to support
Yes.
that point.
Yes.
If my memory serves me right, I remember when JPS made their submission, that was a critical issue, because they were saying that many of their tasks, they subcontract it or outsource it, and therefore we're asking the question, in that context, who would be liable? Because they are the primary company, but they outsource, and they have done that the meter reading, the debushing light posts and so on, many aspects of their responsibilities. So to support Senator Brown and ask a question, those workers, so would that subcontractor be captured under this new definition? And hence the workers, whosoever employ them, they are workers in the frame of things, and the bill should also capture them. So would that be so in this new revised definition?
Yes, because I've used the term of contract for services to cover the wider contract workers. But in terms of, we always talked about the chain of responsibility. So using the JPS scenario, we have always been saying that the bill speaks about to the extent that you're able to manage or control. So you have, in that relationship, you have the PCBU who, well, I don't really want to use a specific company name, but the first company who would have hired the person. You have the contractor, they're also PCBU. But to the extent that the first company can control certain safety and health requirements, then they would do that. So it's a shared responsibility between the company and the contractor in relation to the workers. So that's what the bill is built on, that shared responsibility. So it would not be enough for company one just to say, I have a clause in the contract saying you must protect the safety and health of workers. They would have to actually, to discharge their responsibility, also make sure that the contractor has actually done what he or she is supposed to do. So right now, a person will just say, there's a clause in the contract. So I don't have to look if you really take care of the safety and health of your workers, because I have that clause in that contract. What this bill is saying that, no, you have more than that clause alone. You actually have to liaise with them, meet with them, consult to make sure it's actually done. Because there's a shared responsibility there for the safety and health of the workers. And that shared responsibility goes all the way to the workers also.
Follow-up question. Your OSH officer goes in. Who would that OSH officer goes to directly? The subcontractor or the parent company?
It depends on who is in control of the site at the time the OSH officer goes there.
All right, so let's say you go to the subcontractor, yeah, you're not getting the type of cooperation that you'd get. Would the officer under this bill has the authority to go straight to the parent company?
Yes, because it's a shared responsibility for the safety and health. So what you can control, you control. And then everybody has their level of control. So that's what the whole 19 to 29 of the bill was setting up, this shared responsibility for the safety and health of the worker.
Mrs. Silibone, you had a comment? Not sure, yes.
Chairman, it's just, again, it's what, are there two sets of contractors
Yes.
being identified in this bill?
Yeah.
Or is it because we're widening the contractor here on page 6 to take them out of 7.1b?
Yes.
Are we including them in 7.1b? I'm not sure.
Yes. I think what Member Brown is really asking is that, based on this new definition, a contractor, like the contractor on the construction site, do you consider them a worker? Since they would be more like the PCBU, they would be hiring persons, they would be dispatching, they'll be giving tasks. I think that is what the question he's asking, Mrs. Cameron.
The fact of the matter is, the contractor would be both a PCBU and a worker under this bill, because they would be a worker to the parent company, so they have a dual role. And that's why the bill says that you can be a PCBU and a worker at the same time.
That's clear now, member?
Looking at the CARICOM model, you see? Yes. It says it has everybody under the rubric of an employer, means any person or undertaking, corporation, company, public authority, or body of persons who or which employs any person under a contract of employment for uses the services of a dependent contractor, commission agent, or a contract worker, and may be an operator, principal contractor, contractor, or subcontractor, and it includes their heirs, successors, and assigns of an employer. They have used the word, employer. They have used the word employer.
Okay.
But what they have done is they have sought to capture everybody under the rubric of those who they have either outsourced responsibilities to or provide service in capturing it.
Yes. All right. So we are.
Mr. Silibone going to comment on it?
I'm just thinking that it would be difficult for us to adopt that definition because of what Mrs. Bennett-Campbell is saying. The scheme of this bill follows a totally, yes, and when I looked at the way it's defined in the precedent that was used, apart from tweaking the language to in some of the paragraphs, it basically says the same thing. So I am mindful to change it without more, really. Because the whole issue of the shared responsibility, that principle, that's not really in the CARICOM draft, is what flows through this draft. And it comes from a precedent that defines it basically the same way. So I'm mindful. But surprisingly, it's not, the term contractor is not defined in that legislation. I don't know why. Yeah, so even in the draft that was used, it could be that it takes its ordinary meaning. We expand it a little bit more in our case. But I am a little mindful to change it, Chair, because...
To change what?
So
change the definition of contractor or change how it's dealt with in clause 7. Because of the whole issue of the principle of shared responsibility.
So in terms of the definition that has been put forward by the ministry. What is your position in that regard? Do you have a comment? Okay, very well. So she has no difficulty in accepting. Members?
My concern, Chair, is how does that definition, in the new one, is it compatible with 7.1?
Well,
Does it?
that's what she's saying. Mrs. Bennett Campbell is saying that it is.
It doesn't strike me that way.
It is very compatible. I don't know if.
If we get into the definition here, and somebody comes and look at 7.1b and says, oh, when it says contractor and subcontractor, we must read it in the context of contract for service, which is what we're saying in the new thing here.
No, I think it is wider than that, contract for services. I think it is saying also like a construction contractor who is there directing the work, he would be also covered under 7.1b as a worker based on the principle of shared responsibilities.
I understand that.
Yes.
But this is not only about shared responsibility.
Contractor for services is also covered based on what is now put forward.
You bring in that, and again, let us be practical. You bring in the contractor has 40 trucks and a mining contract. And you have the security guard, which is called a contractor. You have the worker in a newspaper company up the road, who is called a contractor. You have the MD at Solid Waste, who is described in the contract as a contractor. So, but essentially they are doing contract of service. This doesn't capture the contract of service people. I don't mind you bringing the big one for the share service at 29, but I can't leave out those at the bottom who are called contractors. And I don't know, that's the people who contract of service. Right? So, just to make sure we capture those people in this legislation. And I don't want, because of the definition we choose on page 6 of the bill, that those people are written out at 7.1, right? And that's maybe something that you need to look at, and whether or not we can find some compatibility between the CARICOM model and the shared responsibility of this bill.
The CARICOM draft, it defines worker as a person working under an employment contract, full or part-time, or performs services or provides labor, and includes an apprentice and a trainee. So it's defined just very limited. Yeah.
We've gone broad in our definition here, which I support.
Yes.
But I don't want us to net it out with the definition of contractor.
You're not. Are you saying, Member Brown, that even in redefining contractor as proposed, you don't think it covers the issues that you're raising? That's what you're saying?
Because it goes for contractor means a person who's engaged under a contract for service.
Yes, but Member Brown, I think what the ministry is saying is that for contract of services, those persons are to be regarded as employees under 7.1a. Mrs. Bennett-Campbell? Well, that's my understanding of what the ministry is saying.
Yes, they are employees, and I have to check back the minutes because the ministry was asked to come with a definition of employee, but I have to check back when that was. And we had come with a definition of employee which was similar to what obtained in the LRIDA, but I have to check back the minutes because it was pointed out that we had not defined employee. So those other persons would be employees under 71A. And I have to look back though to
So
find
you're
exactly.
saying that
we came with a definition of employee also because
which
it was,
included contract of services.
that was contract of services, but using the
Okay.
wording that is in the LRIDA. But I have
Yes.
to look back to see what was said by the committee when we came with that.
Sorry, again, I understand where Mrs. Bennett can be going, but you keep referring to the work of the committee. But the work of the committee didn't stop there. The Parliament approved something. And as I understand it now, that's where we need to take off from. What did the Parliament approve in the definition of a worker? And not be looking at the work that went on before, because we have the product. So let's take it from the product and see if the product, how it fits here. I like this definition, and I wish it could be all the laws. But the reality is, I don't want, because we mentioned contractor and subcontractor twice at B and C, an employee of a contractor. But how do we define an employee? Is it one who now carries out contract of service? Because we know fundamentally there are two different types of contracts. Contract for, contract of. If it's a contract of, you're going to be described as a worker or an employee. Contract for may get you into a different category. And I'm not sure on page 6 we have either defined them as A and B, which we probably could do, right? Or because the term however called was introduced in the LRIDA to protect people like the security guards and others who are called contractors but are not contractors. You know, tomorrow in the Supreme Court of the UK, the issue of Uber drivers, whether they are contractors or employees, is coming up for action, for adjudication. In the United States, several states have resolved that issue. A lot of them using the common law principle. So, all the courts in the US, in the UK have so far said they are employees. Right? So, this is not a Jamaican issue. It's a global issue. I mean, I know that, and the ministry is aware that ILO spent several years and couldn't resolve the issue. I think we ended up with a recommendation, but we couldn't get a convention. So when we come to a bill that addresses contractor versus employee, it's important that we try and get what we want in the bill rather than hoping and praying that some creative judicial officer may say, you never really intend that. It wasn't the intention of the Parliament.
Yeah. Mr. Simmons, you wish to make a comment? Yes.
I guess I'm just thinking out loud here. I do think the definition as it is at present has some difficulties, even with the definition of worker. And I do think the definition as proposed is also potentially troublesome, especially for the courts. I'm not sure why we're necessarily moving towards the shared responsibility, which I think is the main reason behind it. But I do think if the persons we're really trying to capture are those contractors who are in fact employees, then we could simply just use the words that we're accustomed to using. Maybe the contractor who in fact provides, who works under a contract of services, and as simple as that, rather than trying to include those contractors who are really employers. Because right now it seems to be kind of muddled to me.
Yes, Mrs.
The effect
Bennicamp.
of that, though, is that we would really only be covering employees under this bill. Because contract of services, those are employees. So we would not be covering workers who are independent contractors.
But
Unless a court goes and holds that they really are employees.
But I think Mr. Simmons is saying that we must expressly state both. Yes.
But at the same time, I'm not sure, accepting what Mrs. Campbell said, why are we trying to put the independent contractors, when I put that adjective before the word contractor, on the worker, when strictly speaking, they should be able to take care of themselves?
Any comment, Mrs. Bennicamp?
Well, I think the ministry has been saying this for some time now, from we've been going through the bill. It's that because it's safety and health, we wanted to capture a category that is wider than employees, right? Because in other laws, it's just about I didn't get a payment or I didn't get leave. I can go to a court and I can get that if the court determines that I'm an employee. When it came to safety and health, we did not want to be caught up in the whole debate as who is an employee, who is an independent contractor. We wanted to cover the broadest set of workers possible. So that was the policy intent. So if we go to employee now, that would mean that that would be a change completely from what we had in mind. We always meant it to be wider than employee.
Any comment, Mrs. Silibone?
I'm just asking, would an independent contractor ever be a worker? In light of this bill, would they ever be considered workers?
Okay, which I
An
think...
independent contractor?
I'll allow Ms. Bennicamp to answer.
Yes, an independent contractor who is also a self-employed person can be a worker under this bill because they're doing work for the PCBU. So under this bill, it was intended that an independent contractor could be a PCBU plus a worker. And so you see the different duties that we have. You have for the PCBU, you have for the self-employed, you have for the work, you have for the employee, you had it going down. So everybody having a responsibility for safety and health, right? So when I was talking about definition, I came back with, though, I don't know if, when I came at the definition of employee, it was at this joint select committee. It wasn't somewhere else where I had presented the definition of in the LRID. But I couldn't, because it is not defined in this bill. So I wasn't talking about another setting. It was this joint select committee that we had come, but I would have to check the minutes to see which one I'd come with a definition of employee.
Appreciate that point about this, JC. But, Chairman, is it possible to define contractors as A, those who are doing contract for service, and B, those so-called who are doing contract of service, so that we capture, so that either of them is captured at 7. But again, my fear is by defining contractor in one way here, in the classical sense of contractor, it missed the practical reality on the ground of calling people. The guy who drives, who sells newspaper for the Gleaner, who takes the paper around the country and drop off some in Santa Cruz, some in Alexandria, some round Junction, he's called an independent contractor. If you take somebody like Mr. Moore, who is passed now, but Mr. Moore used to go around the country and drop off the newspaper for the Gleaner. And the bread van, there are a lot of these type of businesses that are independent contractors. And so for me, and there's the one who gets a third party contract and does the job. That's a different person from those in the regular workplace. Sometimes work called wrongly contractors. So does the term contractor here cover both?
Well,
We do it at 7.1, we attempt it at 7, but I don't know that with this definition of contractor.
well, I think, based on my understanding, I don't know if Mrs. Silibone can assist us. The definition as put forward for contractor here by the ministry does not include contract of services, because the position of the ministry is that contract of services, they are employees. So I do not, and I have heard you, Member Brown, but I do not know if the draft, having heard from the ministry, is able to assist us in that regard. Yes.
They would fall under the category of an employee.
Give you an example that I'm aware of. I don't think the person would have taken offense. I had to deal with the case of the general manager, our executive director of the solid waste. The contract says contract for service. But in reality, it was a contract, that's what the contract says. And there are several contracts around in the public sector that tell you you're a contract for service. When you go below it, you find that it's very much a contract of service. But the argument could easily be the express words of the contract is a contract for service, and therefore you can't come to the court to say it's a contract of service because you signed for service. And I've seen a number of those contracts around the place. So that, I mean, somebody come to me recently, an international agency, but what are you looking at? It's a contract for service, yet a lot of it, hours of work and so forth, doesn't show a contract for service. And that's the dilemma. A lot of people sign these contracts. It is only covered when they get into problem and they come to you now and you ask them, oh, you could have signed this.
Yes, Mrs. Silibone, I do not know if you're able to assist us here. Yes, you have to use your mic. I think what is happening here, the ministry is relying on the use of the word employee under 7.1a to cover the concern of Member Brown. But I do not know if you have to, it could be expressly stated in the legislation here, or you believe that that is, yes.
As we were saying, we wanted to adopt a definition that was nearer to the LRIDA for employee, so that you get the thing, however, this whole language about however it's described, and talking about control and different tests that really make you an employee. So the definition of employee would also be key to make that distinction. But those persons, yes, they're considered employees. Case law has shown that irrespective of the label you use, there are certain common law tests that are applied in every case to determine if you're a contract of service or a contract for services. So no matter the label you use, when the court looks into the true relationship, then they will determine who it is. So it doesn't matter the label that you have thrown on the relationship.
But employee is not defined.
I'm going to now jump in just to say, but you're going to have an issue if you have a law that sets out a very specific definition. So if you go to court, the court is not going to be able to do much wiggling around whatever you put in your law, which is also the other issue we were raising earlier about when we're codifying our common law. You have to be careful how far you go, what you're doing. Not that you can't do it, but you have to be careful and know your intent. Be very precise about your intent. The court can now exercise more discretion when you don't have the prescription that you're perhaps putting in here.
Yes. Or use the common law
So, am I to understand you, Sergeant, that, having regards to what the ministry has said, the reference to employee here may be sufficient in these circumstances? No. Yes, yes.
Now, I'm really not sure, do you know why? Because we still haven't settled on some other terms. We haven't settled on like the PCBU. We haven't settled on some other things that, to me, if we know the establishments and how far we want our remit, to me it will help to guide the discussion on all the affected persons. And that is why I'm still hesitant.
Very well. To take on the, yes.
There are some very sensitive areas of this legislation that has formed itself into strong debates around it. And what we may have to do at this stage is red flag these critical, sensitive areas and maybe do some more homework on them. It is always going to be debatable as to what we're trying to achieve and what we're trying to protect. And I can understand this one where we're talking about an employer, a definition for independent contractor. How I look at the term or the definition of contractor here and see how it's treated in 7.1b, it's going to pose some challenge later on, right? But let's not detain ourselves on it, red flag these areas that today, in my mind, this era, this what we're dealing with in terms of definitions, would have been the area of most issues, right? And that's why we leave it for the last. So I would suggest that this is another one that is going to be critical, that we may have to sleep on it and come back.
Mrs. Silibone? Yeah. Yes.
Well, the problem I have is we are taking something from somewhere that has this whole scheme and principle which deals with shared responsibility, Chair. And that is why it is defined. Things that this provision is defined in just like what Mrs. Bennett Campbell is saying. If we have to be careful how we tweak it. What I noticed, however, Mrs. Bennett Campbell, is in the precedent that was used, contractor is not defined. And I'm wondering if that may help. Because we know that the employee would cover the situation that Member Brown was speaking of. And maybe the confusion is arising because we're trying, for whatever reason, to define who is a contractor rather than just saying it has its ordinary, the meaning that it would have, its ordinary meaning. And I don't know if, Chair, that is the problem. I think we need to figure out whether or not we really need to define it in light of the discussion that we're having, because I think it's created more confusion when we define it. And if we try to limit it, Member Brown, it may be that the whole scheme of the bill, as Mrs. Bennett Campbell is saying, that speaks to shared responsibility and all of that, we may create some changes, it may have implications for how the rest of the bill is drafted because of the scheme, and that is why I'm a little cautious. I'm being cautious as to how we should, whether or not we really should change anything based on what comes after. So maybe we should just flag it for now. Let's not waste so much time looking at it right now, Chair, and then we see how it's used throughout, and maybe we make. And or whether or not it can take on its ordinary meaning, and we may not need to define it any at all, Chair. Because as I say, it's not defined in the precedent.
So we will take on that suggestion. Yes?
I hear that, Chair.
Yes.
I want us to move on.
Yes.
Because I think it's Senator Gale proposed we have to come back to it.
Yes.
And I say this because I'm so much aware of the difficulty at the workplace about who is contractor, who is not contractor. In other words, we operate in an environment where you have a set of unionized people here, some other people in the same call center doing the same work, but called contractors. It happens in other sections of the industry, in the hotels, in backside. You just label somebody contractor, and I'm fully aware that 3 years the ILO spent trying to work this issue through. I know it's not a local issue. It's a global issue. But it doesn't prevent governments. And if you go through the ILO document, you've seen some governments have boldly faced this. And this is where I think if we're going to make a fundamental law like this, we ought to be prepared to boldly face it. I mean, Chairman, I recall the late Bobby Barr, attorney at law, moving some of the security companies and others into contract. Senator Gill and I are aware of one of the most litigious counsel when it comes to industrial relations. Yeah. So that we want to avoid getting into things like that. So that if people are going to look to pick this bill apart, and so when you come to a definition like contractor, it's important that we lock it in a way that prevent people who want to pick it apart and destroy the bill. The act when it comes, right? It's good.
All right, so we will revert to the committee on this clause. So we can move on. Page 9, critical substance, Mr. Mohan.
Critical substance. The OPC raised some comments, and we try to have it here. The terms in categories. The first one is terms that are defined but not used in the substantive provisions of the bill. And these are listed here. Critical substance, engineering control, HIV-related discrimination, HIV negative, HIV positive, HIV status, homework establishment, medical officer of health, occupational health and safety expert, prescribed high-risk plant, risk, safety and health duty, technical examiner, and work-related disease. The recommendation was that these terms are not used and should be deleted. So in response to that, the ministry agrees for the deletion of terms set out from number 1 to number 7. The ministry also recommends that the deletion of the following terms from its assessment, as they were not used in other clauses. I want to also, HIV testing, infringement notice. We have major hazardous installation, but this was there in error. This should not be deleted because it is used in the definition of construction. Ms. Silibone had made reference to looking at construct and construction to redo the definition, so at that point this may be a part of it. So we're not recommending the deletion of major hazardous installation. But we are also recommending deleting the word supervisor, the definition of a supervisor.
So we have Mrs. Silibone had asked that we defer construction. So, Mr. Mohan, I'm trying to understand, in terms of critical substance and the definition as we have here, what are you putting to the committee?
We are recommending for it to be deleted because it does not appear in the substantive provisions of the bill.
Okay, very well. Members?
Before we go to delete anything, I understand, but maybe it's a sign that it should be included rather than deleting. And so, the issue of HIV, this bill ought to be inclusive of HIV. The people came here from the seropositive, Jamaica network of seropositive. They said they like the bill. Are we going to keep the issue of HIV testing and so forth in the bill? Because, oh, no, not the testing, but the provision relating to not testing and so forth. In other words, is there sufficient protection for the HIV, people living with HIV, and the HIV-related issues?
But not just HIV, because let me just try and grasp what is being proposed here, because what it says is terms used but not terms defined but not used in substantive provisions of the bill. Not used in substantive provisions. And they say that not used at all. One. And most of these terms that are being proposed to be deleted relate to health. Huh?
Use the mic, Mrs. Silibone. I think you should keep it.
Remember, we have an entire part that deals with the whole issue of discriminatory conduct. Always saying, we're not asking, it's not our bill to tell you to take out or not put in anything. All we're saying is that if terms are defined in the bill and they're not used, that's just a drafting rule. They can't be in the bill. So right. Yes, so that's the only issue OPC is raising.
The question is, should the terms, should we be filling out those terms in the bill?
And what my greater concern is that it's a lot of healthcare related terminologies, including things like critical substance, which in my mind, medical officer, etc., safe and healthy duty. We're going through the process of the bill, but it is already in my mind lacking from a medical and a health input. So now to be also removing the few references.
That's a different discussion to have. We're speaking from a drafting perspective. If a term isn't used in any legislation, it can't be defined.
Well, it says it's not used in substantive
meaning that
provisions.
Even if you use it in a schedule or, to the bill and there's no substantive provision to back it, it can't be used. So you're having a different discussion now. Yeah, but that's a policy issue.
This committee is saying that in looking at the bill, having gone out and say in drafting we want to deal with these things, I need a reason why the HIV protection to citizens are not in it. But no, I agree with you. I understand fully what you're saying. It's not here. It's not in the bill. Maybe policy has dictated so. But I don't understand the policy to be to shut out the HIV issues, which is what I understand, Senator Langmore.
But there's no policy to shut it out. I think if you understand what Mrs. Silibone is saying, don't ask us to keep these clauses in our bill when there's absolutely no reference to them.
Don't ask you to keep it empty. Fill it and keep it.
Yes.
Chair.
All right, we'll take it in order. We'll listen to Member Gill, Member Cuthbert, and Member Longmore. Yes.
As it is now, as the bill that is before us, it is not, these terms are not used in any substantive way, or any at all. But having listened to stakeholders, are we saying that the stakeholders never raised any issue that may include the use of any of these terms in any way, shape, or form? Having heard the stakeholders' submissions. Because they might not have been represented at the time the bill was being drafted or presented to us, but post that. And that is what I would want us to satisfy ourselves on.
Yes.
I think if we look at part 6, Chair, page 76, clause 103, going right down, it deals with discriminatory conduct, and it actually states what will be the yes. And HIV here it speaks to HIV or acquired immunodeficiency syndrome, so there's no need to really define it, but we have dealt with it. It may not be that you understand the point I'm making, Chair? So taking it out is not that, it's not our intention not to deal with it. It is just that we're saying if these terms are not used in substantive provisions, you can't have it. But that is not, I think what we are describing here now is dealt with very adequately under part 6 of the bill.
Mrs. Benny Campbell?
No, I understand, and my contention wasn't that the discriminatory and the HIV specific issues are not being addressed. But if we were to look, let's look at the definition of critical substance. Means a chemical substance, a physical or biological agent or combination thereof to which the exposure of a worker is prohibited, regulated, or restricted. You're telling me that throughout this whole bill, that definition is not relevant?
The express words of critical substance. That is what you need to look at.
It's not that, it's not that you, it's not that.
No, but what I'm saying is throughout the entire bill, there is no substantive reference to critical substance?
What could have happened, member, is that you would have spoken to a chemical substance or physical or biological agent or whatever, which you have, where persons are exposed or where exposure is prohibited. You just have not used the term critical substance. So because the term isn't used, we can't put it in the definition. It doesn't mean that we haven't dealt with critical substances. It's right. It's not used as its
same thing for medical officer?
Yes, but medical...
Same thing for occupational health and safety expert?
No, but you have used it a different way. A different term. That's the problem. It's not that you are eliminating the use of these terms. You either have used them differently.
No, I understand.
Yes.
So let me give an example. Critical substance was actually, it's in the MOR, in the Memorandum of Objects and Reasons, the term. But the term is not used throughout the bill, but the term itself is captured in the bill. So I think that's the issue. So it could be, though, that where we go to the places where it is captured, that perhaps you could consider reinserting the term, depending on how it is used. But for right now, all we're saying is the term isn't itself used, but generally most of these concepts are still captured in the bill.
But they're not used.
No, so the term critical substance is actually on page 197 in the MOR. Okay. So it's actually there used that way. So you wouldn't define it because it's in the MOR, but the concept is there. So that the term medical officer isn't used, but there's another term that relates to medical officer. Right. So it could be, though, that there just needs to be a little bit of reconciliation with some of the terms, and reconciliation generally.
Mrs. Benny Campbell, you wish to make a comment?
Yes. I remember when we got to discriminatory conduct provisions, the committee concerns were raised about those provisions, and we were recommended that we went and changed it to reprisals. So we no longer have discriminatory conduct provisions in the same way. We have reprisals. That is what we came to the committee with based on recommendation. As to how the HIVs worked back in, we still have to figure that out, because it no longer falls within the scheme of that particular scheme. So we no longer have discriminatory conduct in the bill. But Based on that was based on recommendation. You told us to go and look at reprisals. We came back and the committee approved these reprisals, all these provisions for Part 6. We came back on 2 occasions.
We don't use risk throughout the bill? No, I mean, I think we need to really look through. I think we really need to, because my underlying concern is that a lot of these are health related, and my angst to the health representation and the technical representation throughout the entire bill. So I'm.
Oh, but there's no recommendation to delete risks. No, if you read it carefully on the Part B there at page 9.
The ministry
Yes, the ministry's response is not
We
proposing.
never finished.
It's not. No.
Our responses are not finished.
Yes, our response is we were just reading out what was a recommendation, but we did not respond to them, to all of them.
Chairman,
Member Brown.
this bill was held up because we wanted to include protection for people with HIV. There's only one subclause, 105B, that deals with HIV. And for me, the issue is, have we done and put in enough to address the issue? And I agree with Mrs. Silibone. If the clause that we want, if the definition we start out with is not in the bill itself, there are 2 rules. Pull it out or put something in there to cover it. Maybe when I'm going to write something, I write down a note of what I want to write. Then I fill them in. And I'm wondering if in this case, the issue of critical substance and so forth shouldn't be filled in rather than take out the term critical substance. Sorry?
Not the way we draft, Member Brown. So I can't say to you, because we have not, my involvement with this bill has been late. I don't know that is the way that you draft, that you put down a definition and you come back to put it into inserting it later. It could have been, this bill has gone through a lot of different stages. It could have been in a previous draft. Something was there that was deleted, I can't say. That's as much as I would say.
Well, all I want is to make sure that the bill, and we're talking here policy, because if you get policy direction, then it will go in. My concern is to make sure this bill does the protective work that it needs to do for the people. And so I see the technical position. If there's nothing in the bill about critical substance, then take it out.
It's not that there's nothing in the bill about it. The bill may deal with critical substances, but it's not, the term of art, critical substance, is just not used that way in the bill. And that's just it. So it's not that it's not dealing with it, it's just that it's not defined. It's that it is not defined as critical substance in the bill.
What I want to ask, Chairman, is that Ministry of Labour look back at this issue and see whether they are satisfied that removal is the route rather than backfilling, if I may use a construction term. So I would like to hear from them in terms of policy, whether or not they are satisfied that what is here now allow for a deletion and not an undermining of the protection that we seek. And this is because I understand the disconnect between the drafters and the proposers of the bill, etc. But I want to make sure that it's not a deficiency in proposing that now leave the drafters in that position.
If you look at the definition very carefully, right, it speaks basically to biological agents or a combination of chemical substances and biological agents, and chemical is defined and biological agent is defined, so maybe there would have been a clause in the bill that spoke. Yes, yes, so it could have been that it was used in another provision in a different way and it was taken out, and it would be, they just omitted to take it out from the interpretation. But it's not that we haven't dealt with the things that it defines, it's just that we haven't used it as a term to include both.
Yes, yes. The ministry, we're going to hear from them, but I'm sure they have taken note of your proposal.
Yes,
Yes, Mr. Mohan.
Member Longmore, as what Ms. Silibone has said and others, the concepts have been captured elsewhere, because if you look, there's a definition for hazardous substance. So although the definition of critical substance you're recommending for is deletion, if you read the definition of hazardous substance, it tries to capture mixtures of substances, biological, chemical, physical, or toxicological properties, either singular or in combination, and constitutes a hazard. So it links it to that conceptually. So taking out critical substance from the bill is not taking out.
What I'm suggesting is that because it clearly is a contentious issue and somewhat sensitive, we're making this decision now. Perhaps we should create this deletion list to be reviewed towards the end of this process rather than at the beginning so early. Where as we go along, we recognize that, okay, these really did not, because we're at critical. I mean, it is hard for me to see that safety and health duty is not utilized throughout the bill, but I guess, if the drafters say it is so.
Mr.
Yes.
My understanding here that we want to come to some consensus at the committee so we can move to some redrafting, quote unquote. But if you're going to revert everything, then we're not going to start redraft. I don't mean what you're saying. There are a number of issues that we have reverted since, but I'm just saying, no, yeah, what I'm saying, you can do it both ways. You could start the drafting and delete it for the time being, but as you proceed, you can always insert.
Yes, good suggestion.
Because in starting to move to drafting, if you don't delete, then it might hold up the drafting process. So it's just for efficiency. So it's best to take it out now because you don't know what you're going to do with it. It's clear that the exact rationale for having them is not in the provisions. It does have a definition. So it's easier to remove it now and continue. And when if you should reach a provision and you realize that I need to insert, then you can do so. It just so a practical approach I'm trying to get.
Very practical.
I note the ministry's comment,
Yes.
where they say that where we have the term duty throughout the bill, we must replace it with safety and health duty, so that will be taken on board when I'm drafting.
Yes.
So it's just that maybe it was intended to use, in this case, safety and health duty, but only the term duty was used. So they're asking us now to just change that language and use safety and health duty throughout. If you look at the comment on page 9, Chair.
Yes, I've seen it. Mr. Simmons, before we get back to the ministry, you have a comment?
I believe Member Scoffrey and
Yes.
Ms. Silibone basically
They have some
safe to say that safety and health duty actually is defined in the bill, which is why it probably doesn't need to be defined in the interpretation section.
Very well. So, Mr. Mohan, members.
So as I proceed, we want to also say that for the recommendation for 10, and which is 10 from the OCPC prescribed high-risk plant.
Yes.
I'm still on page 9.
Yes.
I'm just completing the submission. So yes, prescribed high-risk plant, and the final one, work-related disease, to also have them deleted. As it relates,
We're asking for those things to be deleted from them. Yes. Members? Bear in mind what Member Scoffrey has indicated, that once the drafting commences, if we need to reintroduce, then we will reintroduce. Yes. All right. So move on, Mr. Mohan. Members agree?
So finishing the rest now at B3. The following terms are used in the bill. However, the MLS recommends the following corrections. That occupation health and safety expert is changed to read occupational safety and health expert. Therefore,
We agree to
clause
that, members? Very well.
the
Proceed.
term risk is used throughout the bill. For example, clauses 17 and 18. So we're recommending that is retained. Part 2 addresses.
So your recommendation is that it be retained, members? Yes, taking them as we go.
Part 2 addresses the term safety and health duty. It is accepted that save and except for the heading, the term safety and health duties is not used. As the reference to a duty under this part is in effect a safety and health duty, wherever the term duty appears in this part, same could be replaced by safety and health duty. The Joint Select Committee is reminded that clauses 20 to 34 are to be redrafted.
So we agree to that, members? Wherever the word duty appears, it be replaced by safety and health duty. Yes, proceed.
The term technical examiner is used in clause 133 1I.
So you're asking for that to be retained?
So we're asking for it to be retained.
Members, proceed.
In terms of the comments, occupational safety and health expert, this term does not appear to be used in the bill. However, C section, we have dealt with that already.
Move on.
So additionally, the ministry recommends that medical officer of health should be corrected to read chief medical officer. This term, chief medical officer, was used in the 6th schedule of the bill. However, note the recommendation in relation to the definition of advisory council on page 1 above. The 6th schedule will no longer be necessary. However, in keeping with the recommendation of the OPC that provisions should be included in the bill specifying that occupational diseases should be referred to the chief medical officer by the authority, the term may still be relevant. And this is follow up on what you had raised some sittings ago, Memo Langmore, in regards to if we were to put it in the regulations or on the face of the bill, and the OCP recommended that we put it on the face of the bill.
We agree, members, that medical officer of health be corrected to read chief medical officer. Very well.
Yes. A correction though, that term is used in the Public Health Act because medical officer health is actually used in the Public Health Act.
Yes, in terms of the referral, it is first referred to the chief medical officer, and then the medical officer is the one who, the chief medical officer who does the referral to the medical officer of health for that parish.
That's what I wanted to clarify, because depending on how it is used throughout the bill, the chief medical officer's role is very different from the medical officer of health, which is different from the medical officer.
Right, and we
I
recognize that.
I need to be reminded of where it is referred to within it for us to know which. So they're not interchangeable. Medical officer of health is not interchangeable with chief medical officer. Two different positions.
Which I think that is what the
CMO, I think, is a post on the establishment, but when you go to the Public Health Act, what you have is medical officer health, and you also have medical officers. Even in the Disaster Risk Management Act, we refer to both medical officer health, medical officer. And in most other legislation, sorry? Right, but a lot of times, you see the chief medical officer is still going to be medical officer, right, and it's usually a medical officer health, but the laws, a lot of the laws do give specific responsibilities to either medical officer health or medical officer. But we don't usually refer to, I don't recall us in law referring to the CMO.
That's my concern in terms of it just being interchanged here.
And we've looked at a few laws recently.
And
it's usually the other terms, not CMO.
And we have to recognize that a medical officer within the public system is different from a medical officer in the private system. So if, let's say, a worker goes to seek a medical certificate, I'm not sure exactly in this kind of blanket change, you could be providing a confusion as to what role that healthcare person is playing.
So what I would suggest is that they use the Public Health Act as a reference, because the Public Health Act defines a medical practitioner, which is a different person. So I think really what the ministry should do is just consider the discussion. If you're going to refer to the medical officer health, then you use that term as defined in the Public Health Act.
So the ministry will come back in that regard. On the recommendation of Solicitor General, certain consultations will be done with the Public Health Act. So we can proceed, Mr. Mohan.
All right, the other recommendation.
Terms used but not defined in the bill, that's where we are.
Right, but we also want to include that for plant, they should be removed to the margin as how it is set out in the bill. It should be removed to the margin.
Where specifically?
It is in the line. Physical agent. Under the definition of physical agent, it runs into the definition, so it needs to be moved to a new line.
Oh, very well. So plant, as stated there, should be in a new line.
Right.
Good. All right, so we agree to that.
All right, so now we are at terms used but not defined in the bill. That's from legal reform. Conciliation officer, hazard correction procedure, relevant entity, as seen in the definition of branches of economic activity, factory, function, plant, and relevant worker. So we're just going to respond to them. The ministry recommends that the following: the term conciliation officer should be deleted, as based on changes made, the term will no longer appear in the bill.
Where does this appear in the bill, Mr. Mohan? I think you will have to guide us.
Well, he looks class 76 is 76, 7 is 76, 6 and 7 would be one.
Clause 76, 6 and 7?
76, 6 and 7 would be one instance.
76.5.
Yes, so just remind the committee as to why this is no longer relevant. Our members, you are quite clear.
You want to go?
Mrs. Benning-Campbell?
Yes, I know that we had, while we were to revert with the committee, it wasn't that there was going to be anything to refer to conciliation anymore, because we would have been prescribing the constitution of the Joint Safety and Health Committee. So there wouldn't be something that you'd be referring to conciliation officer. But the bigger point we had made, though, is that even in relation to reprisals, you refer to the Minister of Labor, not to a conciliation officer within the ministry. So that was our bigger concern. So we had taken out any reference to conciliation officer, bearing in mind the scheme is for you to refer to the Minister of Labor in those instances, not to a conciliation officer.
Very well. Members, we agree to that? Yes. Proceed, Mr. Mohan.
For hazard correction procedure, we are recommending that it is defined as any procedure that is instituted to eliminate or reduce the risk of occurrence of injury or illness in the workplace.
Members, do we have any difficulty with that proposal? The introduction of a definition for hazard correction procedure. Control. Administrative control. Okay, very well. So that is subject, Mr. Mohan, to the finalization of the definition of administrative control.
Well, administrative control is just one of the measures of hazard correction. There are others, for example, engineering controls, but it was not used substantively in the bill, so we had recommended that it is removed. Yes. This is a technical term, and it really speaks to the approaches that you would take in trying to eliminate or reduce as far as possible hazards that exist in the workplace. So administrative control.
So you are recommending that hazard correction procedure be deleted?
No, I am recommending that there is a definition for hazard correction procedure.
Okay.
Because it's a term that is used to capture the different approaches that can be taken to eliminate or reduce hazards in the workplace.
Oh, very well.
So rather than list them expressly, and they are not substantive in the bill, we use one term that captures all of that approach.
So you're saying that, yes. So this definition, you're saying that the finalization of administrative control will not impact this definition?
Yes, it would not.
Yes. Okay, very well. So we agree, members. Very well. Proceed.
So for point 3, relevant entity, as raised by legal reform, this is no longer required in the bill because of the fact that we have been recommending the removal of branches of economic activity.
Members, we're deleting relevant entity as seen in definition of branches of economic activity. We agree? Yes. Proceed to factory.
Right, so factory is used in the bill, so we are proposing this definition. It has many parts. So I'll just go through.
Definition drawn from, Mr. Mohan, you could just tell us?
Well, this is a combination of the definition of what constitutes a factory under the Factories Act. So we looked at different models. We looked at the CARICOM model, and we recognize that the definition of factory in there is much limited than even what we have in the Factories Act. But we looked at the definition of the Factories Act, and we expanded it to also include some other definitions. We just want to ensure that we capture as much as possible what constitutes a factory, because especially when it comes on to the provisions for registration, we want to be very clear as to what falls within. All right. So we have it here. A factory means any premises in which are with the closed curtilage or precincts of which workers are employed or engaged in the making, altering, repairing, breaking up, mixing, or adapting for sale any article for the purpose of gain or trade, and over which the person conducting the business or undertaking has the right of access or control. B, it includes places where workers are employed or engaged to perform work activities at. We try to disaggregate the work activities here. Any dock, the first one, any dock, dry dock or yard, including precincts thereof, in which ships or vessels are constructed, reconstructed, repaired, refitted, finished, or broken up. 2. Any premises in which mechanical power is used or which 10 or more workers are employed or engaged in manual labor in connection with the business of sorting any articles carried on as preliminary to the work of any factory or incidental to the purposes of any factory. Any premises, 3. Any premises in which mechanical power is used or in which 10 or more workers are employed or engaged in manual labor in connection with the business of washing or filling bottles or containers or mixing or packing articles on incidental to the purpose of any factory. 4. Any premises in which mechanical power is used or in which 10 or more workers are employed or engaged in manual labor in the business of hooking, plaiting, lapping, making up or packing of yarn or cloth which is there carried on. 5. Any laundry or dry cleaning operation in which mechanical power is used or in which 10 or more workers are employed or engaged in manual labor, including where the laundry or dry cleaning operation is carried on ancillary to another business or undertaking.
Yes. Should we take this as read and members will state, or you wish?
Easier.
Yes.
Yeah, that's the, he had broken them down into industries or sectors or something like that. I mean, we really have to go through this to see what he may have missed.
And yes, I just to read and for us to say, yeah, nah, without some technical guidance. I mean, you can't.
But Chair, it's clear the technical people are saying, how is that? So maybe they need to consult the review cameras.
But only that, but A seems to capture everything else. A seems to encompass all of the law.
And from the Factories Act.
Did you reference it from any other jurisdiction?
Well,
you said the
yes.
CARICOM one would appear limited.
Yes.
And in comparison to yours, anything would appear limited.
we look
but the
at
point
others.
I want to make is that since you have gone so expansive, we have to be sure that nowhere would have been excluded that would have been defined as a factory. Because you have given us a detailed prescription.
But what I'm saying, A encompasses everything.
I don't know, that's what we're asking.
Look at it.
No, it's long, but it doesn't mean that.
No, I mean A here, this, just A, not B, just the A, but where you have a broad thing regarding alter, repairing, breaking, making, mixing of any article for purpose or sale, gain, trade. That encompasses everything.
Yes, Mr. Scoffrey.
The technical persons are here, though.
Bacon, that's it.
Yes.
But for a definition purpose, I don't know if you'd have to list all of this in the bill. I'm not clear.
Let me.
It's class 4 on a definition, so can you have a broader definition that is summarize what you want? I'm not clear.
Yeah.
This like you want it to be the 10th or 11th schedule.
Well, let me hear.
Can we ask, though, that perhaps the ministry can, again, just do a review? So, for instance, Mr. Basco is showing me in Trinidad. Now, it's true it may be more limited than what we have, but just how they have gone about it, the approach is what I'm talking about. So they have factory means premises in which or within the curtilage of curtilage or precincts of which persons are employed by way of trade or intended trade or for purposes of gain in or incidental to any process. Now this is what's important. Process including A, making, demolishing, altering, repairing, warehousing, ornamenting, furnishing, distributing, cleaning, washing, breaking up, or adapting for sale of any article or product, or filling of containers, slaughtering of animals or poultry. Then they look at cinematography, storing of gas. What I'm saying is they have categories rather than drilling down into biscuits. We looked at 25.
No,
we
look
talk
at
about the making of biscuit.
No, man, look at 21.
Like biscuits, but
Any premises used for the breeding of birds where the number of birds is more than 1,000 per flock. So if you have 999, you don't qualify.
Mr. Chair.
I just think in terms of the approach, there must be another way to sort of condense it and make it a little more general, because again, I'm always usually a little scared when we are too prescriptive and then you actually miss something, or we don't look far enough ahead in the future because we don't know. And you don't want to have to keep going back and changing the definition by a long drawn out process as well.
Yeah.
When you have any premises where the slaughtering of cattle, sheep, swine, goat, birds, or any other animal is done. So you don't want to name the rabbit in it.
Mrs. Silibone, Mrs. Silibone, do you have any yes, any suggestion? Yes. Yes. Member Brown, you wish to, Mr. Simmons, then I'll go to Member Brown. Yes.
Yes, Mr. Chair. I do believe this list is possibly even longer in the current Factories Act. I do think that the approach, as mentioned by the Attorney General's Chambers, could be used. But even with this list, I'm seeing some repetition already. For example, I don't think they need to go back and define dock, because dock is already defined in the Act. And maybe this section deal with breeding of birds, maybe that can be captured under agricultural undertaking. So there may be, even if we're to keep a list like this, there may be specific paragraphs that we can take up because they're already defined elsewhere in the bill. But just to caution the committee, I do think that factory will necessarily be a more involved definition than the others.
Very well.
Mr. Stevens, is that term being used now inelegant, and therefore maybe it is inelegantly stated. Maybe there can be some elegance to the definition. I'm not going to get into trouble. I'm not going to let you carry me down that road about market me, but the elegance and inelegance. No, I'm not going on that road.
All right, Ministry. You have heard the comments, and certainly the committee expects that the Ministry will come back to it in respect of this definition.
Chairman,
Chair, if I may,
sorry, go ahead.
just to point out that the reason why we did this extensive work is that when it comes down to registration, there was some discussion about the categorization of registration. So for example, even what Member Gill mentioned about having 999 birds, now if we were to just do it by industry, it means that if you have 5 birds, you would have to register under the provisions for registration, because you'd have been classified by a factory. And listening to the committee at the time at that sitting, I didn't get the mood that the committee wanted to just use a general approach in such a way that we are capturing the little small persons out there to be registering their premises at factory. Under the current Factories Act, we have 17 definitions of factory, and we were contemplating that we would be moving all of those into this new regime for registration as factories. So the other additions were just to try and ensure that we don't have this broad approach that is going to cause some of these other smaller entities that are operating to be required to register under the bill as factories.
Yes, Member.
Your registration must be zoned towards registering establishments outside of what you have expansively determined here as factory. But you're going to register offices and then based on the number of persons that operate within those offices. So are you going to create a different dispensation for that as opposed to factories?
What happens is that for the registration of factories, no, the regime is 3 years. So we're thinking of using that same time for the registration period. For the offices, it is contemplated that will probably be 5 years or 7 years. And if you remember the discussion that we had, we made it sure to point out that the registration is not a means of saying that we are going to not inspect. It is really, you're right. So in terms of the time frames, there will be different time frames based on how it is categorized. So some will be 3, some might be 5, some might be 7 years. It's depending on how it's categorized. So this definition of a factory, as legal reform said, it was really to try to be expansive enough to capture what we define as a factory. So when we have registration, we don't have any ambiguities or it is unclear if you really fall within this definition and you should register as a factory versus you fall within what constitutes an office.
So it's the same scope you're going to use when you define offices, right?
Well, offices, if you look at the definition for establishment, office will not be, and once you go further on in the matrix, you will recognize that we will not be treating it a office like a factory. They will be separate. It is the intent to register offices, but the registration period will not be the same as the registration period for a factory.
And would it be size of the office will determine the registration?
The size of the office will determine the fee for registration, not the registration. Just as what obtains in the Factories Act, based on the number of workers and the size, will determine what is the fee structure.
Could we be, for next week, be sent this specific section of the Factories Act, as well as if someone else, we would certainly get a chance to look at this, and I think you're going to send us the Trinidad thing so we could compare. And I never saw Ms. Silibone hold her head in all the sessions there have been, and so this may be a convenient time to just, yeah, and so I will go back and review this and come again whenever. And it is short enough to get a long day discussion in the Senate.
Yes. So I've heard you members. Through Member Brown, I think he's proposing that this should be a convenient time. So we take the break from the clauses here, and we move on to any other business. Members, I'm advised that we should have next week the JGRE here. Yes. So the question is, do we take them in the morning or do we leave them for the afternoon, as we did for the last groups that were here?
Let us do the more substantive business in the morning session.
Yes.
And take them in the afternoon. My proposal.
Well, very well. I share that view too, members. So we will have them here for next, for the afternoon, for 2 p.m. Next week. Any other business? No, well, I think we will communicate firmly the time that they are expected to be here.
Is there a brief that we can get through JGRA?
We will ask them for the submission so that the members can study it. So hopefully before the week is out, we should have those.
In that brief, could the ministry assist us if they have data on accidents involving gas stations and so forth?
Well, we
Or the
can,
petroleum trade generally?
so that request has been made. Mr. Mohan, you have heard the request. Are you?
Yes, we have noted the request and we will try and provide that information.
Okay, very well. And I suspect it will be over a period of time, over the last 3 years, remember? Yes, I know you won't. Yes, over the last 3 years, I remember Mr. Mohan. So there be no other business. May we have the adjournment for 10 a.m. on Monday, the 27th of July. And again, it is proposed for an all-day sitting. Yes. So it's so moved by Member Longmore, seconded by Member Scoffrey. This meeting is now adjourned.
No matter where we go in this world, once we identify ourselves as Jamaicans, everybody get crazy. They all want to hear us chat some patois like Miss Lou. Hey, so let's wave the black, the green, and the gold. Jamaica, one people, oh, one country, oh.